Ladies and gentlemen, welcome back to the IndieZone. My name is Kathy. I wanted to address some comments that I'm receiving on not just here on the IndieZone at YouTube, but also in the podcast that I've had for the past 8 months, where I have reviewed every single item that's on the public docket and then added in a little bit of commentary from now and then, time to time, regarding the case. The first episode was page 1 of the Affidavit of Probable Cause. The most recent episode is commentary on why I believe, looking at the court's order setting the trial date, that the jury trial's official start date is actually July 30th, not August 11th. But I get a lot of commentary regarding what I call the secrecy of the case and the Mount Everest of documents that have been withheld from the public from the beginning of the case. And from time to time, some of my viewers will say it's the defense's fault, and then other times it's the state's fault. I wanted to clarify that both sides have demanded that, for example, every supplemental discovery request and every supplemental discovery response remain under seal. And this dates back to the first supplemental discovery request and the first response to that supplemental discovery request. All of the items that the defense describes as an attached Exhibit A or attached Exhibit N or an attached Exhibit O, depending on which supplemental discovery request they've served, has the information that they're seeking, and every single one is under seal. One has never been released to the public. Same on the state of Idaho side. Their responses, many times by stipulation, are under seal as well. And the question that I have is why? Why is every single thing that's been requested by the defense withheld from the public, and why is every single item produced responsive to those 20 supplemental discovery requests under seal by the state? We add to this that both sides approached Judge Megan E. Marshall with a stipulated 2 motion for a non-dissemination order that was entered back in January of 2023. So on top of all of the discovery, and this is the evidence that the state has in its possession that Mr. Kohberger believes he's entitled to, that's been requested and responded to, albeit there have been some objections from the state to certain things, such as the IgG DNA evidence that led to a hearing in Latah County last year. Those non-dissemination orders were entered after both sides together went to the judge. First, Judge Megan E. Marshall, and then Judge John Judge, and they opposed, both sides did, when the interveners, the media coalition, attempted to get that non-dissemination order set aside. And quite frankly, Mr. Kohberger also wanted cameras out of the courtroom. And if Judge John Judge did not deny his motion to take out all cameras from the courtroom, we as the public would not even be privy to the public hearings. Judge Judge is the jurist that instituted the protocol that it would be the court's camera that would record the hearings and put it up on first the Latah County YouTube's page, and now it's on the Ada County's YouTube page. But the issue is that there's also hearings from the beginning of the case that the public is not privy to. The latest example was the hearing that was held earlier this month at the request of the defense, to which the state of Idaho didn't even receive a copy of the notice of hearing that was disseminated. Moreover, the hearings, plural, not just one, the titles of the motions that were coming before the court were not cited. We understand that there was a possibility that live testimony was going to be provided. That was not disclosed. So the public is completely in the dark as to what these hearings were all about, what the motions were, and also what the outcome was, because the minutes from the hearing is also under seal. So minutes from a hearing, what you might expect to see is what time did the hearing start, when did it end, who was present, who said what evidence was provided, what testimony was provided, what were the motions, and did the court reserve ruling or enter a verbal proclamation from the bench. We have none of this information. So it's an issue that continues to concern me, that there is so much about this case, and we are now approaching almost 2 years since Mr. Kohberger's arrest, that is under seal, and it is because both sides want it that way. I'd love to hear your opinions on this topic. Your comments are very much appreciated, and I want to thank you for joining us here today on the IndieZone.